No, she emailed it, but it's in PDF and I can't like fill it out. Right?
All rise. The Honorable Stephen L. McIntosh presiding.
Good morning, everyone. You may be seated. Just reminding, no, Pat. Oh, no, we have plenty of time. Okay. Okay. Give one of these to each of the attorneys, and then Jen gets that one also. Right. Plus one of the final instructions.
Thank you very much.
Okay, before we deal with the jury instructions and the verdict forms, are there any other issues on behalf of Mr. Pardon at this time?
No, Your Honor.
Well, yeah.
Well, they haven't listed.
Well,
No, I think the state's going to rest for the record out of the presence of the jury. We'd like to do it again once they come in, but for purposes of making Rule 29 motions, the state would rest for the record.
Okay, yes.
That being the case, Your Honor, would
Yeah.
you like me to make that motion at this time?
Yes, please.
Thank you. Good morning, everyone. On behalf of Mr. Pardon, we would make a motion pursuant to Rule 29. And I'd like to start off, pretty much I'm going to go in the order that the charges go. However, I would like the court to know that I am not going to, we have specifications and we also have charges. So I'm not going to repeat, for instance, I'm not going to keep repeating Rule 29 for rape, Rule 29 for kidnapping, Rule 29 for burglary.
Okay.
And so, with respect to count 1, which is aggravated murder with prior calculation and design, the jury instructions state, which of course is the law, that a person acts with prior calculation and design when, by engaging in a distinct process of reasoning, he forms a purpose to kill and plans the method he intends to use to cause death. The circumstances surrounding the homicide must show a scheme designed to carry out the calculated decision to cause death. And then kind of skipping to the last portion of the sentence, but acting on the spur of the moment or after momentary consideration of the purpose to cause death is not sufficient. In this particular case, I don't believe there is any evidence, circumstantial or direct, with respect to prior calculation and design. There's no evidence whatsoever that Mr. Pardon engaged in a distinct process of reasoning, that he formed a plan, and in fact, the evidence tends to show that this was not a plan, and that even if you look at the evidence most favorable to the state, I don't believe we could ever get to prior calculation and design. With respect to the other counts of murder, as well as the other counts that are in the indictment, there is absolutely no direct evidence, and I understand that circumstantial evidence and direct evidence are the same and do have equal weight. However, when we look at circumstantial evidence and we have to base that on it has to be based on some fact. The way this is, it is a fact that a homicide occurred, and what we're doing is we're going backwards from there and saying, well, because this occurred, then this had to occur. Because this occurred, this had to occur. And so even in, we took into consideration all the facts and put them in the light, giving the state that advantage, I don't believe that it is sufficient evidence to find Mr. Pardon guilty. And so I would ask the court for Rule 29 on all of the counts as well as all of the applications. Thank you.
Okay. On behalf of the state?
Yes, Your Honor. The state believes there's sufficient evidence tending to support each element of each count and specification to overcome a Rule 29 motion, specifically as to prior calculation and design. The coroner yesterday, or deputy coroner, testified that it would take at least a minute plus of the applied pressure of the cords around the victim's neck in order to strangle her to death. He also testified about the, in addition to that, the stab wound at the base of the head, the length of time necessary to tie those cords around the ankles, the wrists, and hold tie the victim would be substantial. And throughout that process, there was a deliberation going on in the defendant's mind. Should I continue to tie this woman up? Should I continue to wrap these cords around her ankles, her wrists, should I hold tie her? Should I put her in the closet? Should I stab her in the back of the neck? The amount of time necessary to take this poor woman and kill her in the way she was provides more than ample prior calculation and design and purpose. And for that reason, count 1 would be overly sufficient based on the evidence the court heard. And at least since the felony murder counts of rape, kidnapping, aggravated robbery, and aggravated burglary all must be in the course of the murder, or while attempting the murder, or while fleeing immediately after the murder. We have the defendant in all of those instances committing the crimes of kidnapping, rape, aggravated robbery, and aggravated burglary while he's committing or fleeing from the murder itself. And the predicate offenses are proven in the same manner. So I think for that reason, the state's evidence would be sufficient for a reasonable jury unproved beyond a reasonable doubt. For that reason, the motion should be denied.
Thank you. Any response?
Thank you, Your Honor. I would just like to respond with respect to the prior calculation and design. I believe that with prior calculation and design, and again, the state has to prove every element, not just one element, but every element. And I believe that with prior calculation and design, the state has to first prove that Mr. Pardon had a process of reasoning prior to the homicide, that he had a plan or he had a scheme to carry out a homicide, and there's been no evidence whatsoever with respect to that. In addition to that, they have to be able to show that, in a sense, he had this plan and then he executed this plan. And so the mere fact that the homicide occurred, and I think that's what the last part of that speaks to, is that acting on the spur of the moment or after momentary consideration of the purpose to cause death is not sufficient. And I think that that's an important clause, because it's not the mere fact that, you know, again, if you believe the evidence and put it in the light most favorable to the state, there simply is no showing of a process of reasoning, that there was a plan or a purpose, and that he planned out a method. And in fact, if you look at the evidence, this is not a situation where the evidence shows, for instance, this young lady was tied up, that someone brought rope, someone brought things to the scene to carry out a purpose. This kind of shows things were grabbed at the spur of the moment. So again, I would ask that the court grant a Rule 29 specifically with respect to that count.
All right, thank you. Okay, as to the issue of prior calculation and design, I mean, the instruction that the court will provide to the jurors is as stated by both parties. However, the court finds this language instructive as to whether or not there's sufficient factual evidence in the record for the jurors to consider. The circumstances surrounding the homicide must show a scheme designed to carry out the calculated decision to cause the death, and that no definite period of time must elapse and no particular amount of consideration must be given. The court believes that that ultimately will be a factual determination on behalf of the jurors based upon the evidence that's currently in the record, whether or not based upon all the facts, whether this act occurred either as a spur-of-the-moment action or that there was some definite thought given as to how and the means and the manner in which the homicide was going to occur. So the court does believe that there is sufficient evidence in the record for reasonable minds to reach different conclusions as to prior calculation and design. Likewise, as to the other offenses, the court also finds that there is sufficient evidence in the record that each and every one of these elements, each and every one of these counts with each and every one of the elements and specifications, that there's sufficient to be given to the juror for their consideration. Again, looking in the evidence and the light most favorable to the state, reasonable minds cannot reach different conclusions as to proof beyond a reasonable doubt of each material element of the offense, and therefore the Rule 29 motion is overruled. All right, are there any other legal issues that we need to deal with before moving to the jury instructions and the verdict forms?
I don't believe so from the state standpoint.
There's not.
Okay. Okay, with respect to the jury instructions, the only changes that I made were minimal. With proof beyond a reasonable doubt, it just read most important of his own affairs. I just added his or her own affairs. I think likewise to the deliberations. think it indicates that I could just added her. And then made the changes that Ms. Roush suggested, which was just grammatical. Beyond that, it's what was provided yesterday. So anything else with respect to the jury instructions on behalf of the state?
No, Your Honor, the state satisfied with the 23-page, 24-page instructions having gone through each page and each offense element, spec, and general instructions.
Okay. Any objections to the instructions?
Judge, I just wanted the identification as Anthony Pardon, perpetrator. I don't think we have identification instruction in here at all.
I think in response to that, each element says before you can find the defendant guilty, you must find the state proof that he, the defendant, purposely caused the death of in the course of the offense or throughout. Certainly, the evidence doesn't prove that the defendant did it, and that would be a failure of proof.
Mr. Thomas, I'm assuming that
So it's not like we have a photo ID or some kind of ID of that nature that needs to.
Judge, I think there's a standard OJI instruction on identification, if that's issued in the case. I believe it was issued in this case.
give me a second, please. But I've included it in several. I'm trying to find the OJI instruction.
The only one I'm familiar with, Your Honor, is one when a victim may testify and identify the defendant in a court pursuant to photo array, and there's an instruction dealing with potential fealties of eyewitness identification. And that's the only thing that I can think of, and that's not present in this case. I don't know if there's another
the one that I'm thinking of, and that's what I'm trying to find it, because I want to make sure that we're talking about the same thing, is that it says something along the lines that the state has to prove each and every element, which includes the identification of the defendant.
As a perpetrator, that's correct.
Hold on. Okay. This is the language that has been used before, so just let me know if this is what you're referencing, Mr. Thomas, and then the state if you're objecting to this language. One of the issues in this case is the identification of the defendant as the perpetrator of the crime. The state must prove identity beyond a reasonable doubt. It's not essential that the witness be free from doubt as to the correctness of their statement. However, you, the jury, must be satisfied beyond a reasonable doubt of the accuracy of the identification of the defendant before you may convict him or her. If you're not convinced beyond a reasonable doubt that the defendant was the person who committed the crime, you must find the defendant not guilty. The value of the identification testimony depends on the opportunity the witness had to observe the offender at the time of the offense and to make a reliable identification later. You should consider whether the witness had the capacity and adequate opportunity to observe the offender. You may take into account both the strength of the identification and the circumstances under which the identification was made. Finally, you must consider the credibility of each identification witness in the same way as any other witness. Decide whether the witness is truthful and consider whether the witness had the capacity and the opportunity to make a reliable observation. Is that what you're referencing?
That is correct, Your Honor.
Okay. On behalf of the state?
Well, I think, Your Honor, as I stated previously, half of that doesn't apply to what we have in the evidence in this case. I think the first half probably does, but the second half would not.
Okay.
And if I could, maybe the court could print it out and we could both look at it and then agree or disagree on what parts of it should be given.
Okay.
And Judge, I don't have a problem having that printed out, but I think that's a instruction that applies. I think that, well, Judge, that we can look at it and then we can go through the arguments.
Okay.
Where were you gonna put it on?
Probably,
It looks like you have it in between expert witnesses and number of witnesses, so in the middle of page 4 maybe? At least on this page you printed, Judge.
say,
You should not decide any issue of fact.
Oh, yeah, it looks like, yeah, you got it right in there. So it would be 1, 2, 3, it would be the first paragraph on page 4. It would be inserted there. It's like, looks like where you have it, where you put it.
At least
okay.
That sounds good to me.
So it would be the 1, 2, 3, 4 paragraphs inserted in the middle of page 4 above, you should not.
After that paragraph or before that paragraph?
Before it, I think.
Yes, in between where expert witnesses end and
You should,
not decide any issue of fact on the number of witnesses. So right in between there.
okay. And all or part?
State didn't object to all of it, Your Honor.
All right, anything else on behalf of the defendant with respect to the jury instructions?
No, Your Honor, thank you.
Okay. All right, verdict forms.
State reviewed the verdict court forms that the court submitted to us last night and they appeared to be in order to make.
Thank you. On behalf of the defendant?
No, Your Honor, we have not to review verdict forms, and we find them, yeah, they're more than that.
All right. Okay, give me a minute to get my secretary to make that one change to the jury instructions. If the jurors are all here, I know some of them had some issues finding parking. We'll bring them in, again, allow the state to formally rest in front of the jurors. I'll ask if there's anything on behalf of Mr. Pardon. You can rest at that time, and then I'll let the jurors know that we're moving to closing argument.
Your Honor, I have a PowerPoint for first close, so we put the screen down and make sure it works before my help with technology.
That's wise.
Judge, I would just like to add that we will renew our Rule 29, we want to correct it, we will renew our Rule 29 after we rest.
Okay.
Understanding that we want to make our exhibits and we will renew.
I think we admitted our exhibits last night, didn't we?
Yes,
So, are we good?
yes. With respect to the exhibits, yeah. And just making sure that there's no objections to what's going to be used on the PowerPoint. I don't know if you had any discussions. My assumption that there shouldn't be, but okay, you just want to make sure that there's no objection.
Anything that's out there, it's been admitted as an exhibit.
Very good. Excuse You're fine, everyone. Maybe you're fine.
I'll be up there. Do you want to?
Do you want it up there? Or you want it to me?
Carl. You know, I was thinking, grand jury last Friday. Do you think he was high? He was shaking. He kept saying 5 cups of coffee. Yeah. But the more I thought about it, just the way that he was acting. Yeah. The more I thought about it, just how, because he kept saying, these cups of coffee. Yeah. I know it. Yeah. He talked himself right out of it. Oh, yeah. No, I did email the bailiff just to say, look, sorry I stuck you with him. Hopefully he settled down some more after. And she said he All rise for the jury. You may be seated, ladies and gentlemen. All right, good morning, everyone.
Good morning.
Welcome back. Sorry for the inconvenience this morning with the parking and everything, so hopefully we'll get that resolved for all of you as easily as we can. All right. On behalf of the state,
Thank you, Your Honor. May it please report the state of Ohio arrest this case.
all right, thank you. Okay, is there anything on behalf of Mr. Pardon?
Good morning, Your Honor. Thank you. Judge, at this time, the defense will rest. We do not wish to present any evidence.
Okay, all right, thank you. Okay, ladies and gentlemen, okay, you've heard all the evidence that you're going to hear in this case. Okay, we're now going to move to closing arguments of counsel. Okay, closing arguments of counsel is not evidence. Hopefully the information that the attorneys provide to you at this time will help you as you are considering the evidence and ultimately deliberating. Okay, because the state of Ohio has the burden of proof, the state will have 2 opportunities to close. So on behalf of the state.
Thank you, Your Honor.
If you need to move the podium, you can.
I'm good, thank you, Your Honor. Good morning, ladies and gentlemen.
Good morning.
First off, on behalf of all the parties, we would like to thank you. You've all been very attentive, you all have shown up, and you all have paid attention this entire time. And we really do appreciate that. Because we do know it's hard. We've asked you to put your life on hold for a couple weeks now, so we do appreciate all the work you're doing. But your job's not done. Now comes the hard part. And I'm going to go through some things, some evidence, and if you remember the facts or the evidence differently, use your collective memory. This is what I remember. And as the judge stated, closing arguments are not evidence. They're here to help you, to aid you when you go back and deliberate on these charges. Aggravated murder. Count 1. And again, you don't have to ferociously write this down. You will get this all in writing. This is just to help you understand how the facts apply to the law. January 28, 2018 to January 29, 2018. You're going to see that date range on all of the counts. And that's because that's the day we knew Rachel was alive and the day we knew that she was dead. You all heard evidence to where you can conclude when she was murdered. But that's why we have that date range. Purposely. And with prior calculation and design, caused the death of Rachael Anderson. Let's talk a little bit about some of these terms. And again, the judge is going to give you the law. Purpose, the specific intention to cause a certain result. Us lawyers sometimes like to mess with words and stuff, but you will have all these definitions back there. Do something intentionally and not accidentally. You're asked to look at the facts and circumstances in this case, including using a deadly weapon in a manner calculated to destroy life. Cords used around her neck to strangle her to unconsciousness. Knife in the back of her head. You think that was calculated to destroy life? I'd submit to you that it is. And you heard testimony about that from Dr. Daniels. Strangulation. Ms. Roush asked him, is this consistent with the struggle? Yes, it is. Compress, release, compress, release. The stabbing to the back of the head. The amount of force needed to chip off a piece of bone of her skull. How hard does that knife have to be shoved in? prior calculation and design. This isn't something where it needs to be mapped out. We don't have to find a journal written about every step that was going to be taken. Didn't have to plan it for weeks. That's not what that means. How many of you have seen Ocean's 11, where they all get together, make the big plan to rob the casino? That's not it. That would count, but that's not what was required under Ohio law. No definite period of time must elapse, and no particular amount of consideration must be given. There isn't a magic formula. But it can't be spur of the moment. I ask you to look at the evidence. 7:59 to 9:25 p.m. Almost an hour and a half. It's a long time. Intricate knots. Think, ladies and gentlemen, of all of the things that were used. Her hair dryer. You had to walk and go get that. Her curling iron. Had to walk and go get that too. Pieces of the blinds. Had to go cut that off. Pieces of her belt. Had to cut that in half. And what about the knife? Downstairs. Every step he took. That qualifies as prior calculation and design. This isn't spur of the moment. How long did it take to tie all of those knots so tight that Agent Durst couldn't untie them himself? He had to cut them off. Compress, release. Compress, release. Does that seem like spur of the moment to you? 4 other counts, and they have different language than count 1, but they're all aggravated murder. And again, same date range, purposely, cause the death of Rachael Anderson, while committing or attempting to commit, or while fleeing immediately after committing or attempting to commit. Those 4 things: aggravated burglary, kidnapping, rape, aggravated robbery. Again, purpose, same as before. Look at the same things, the circumstances, the evidence you've heard surrounding this. The big difference is there's no prior calculation and design required for those counts of aggravated murder. He kills her during the course of or while fleeing after committing, again, those 4 things: aggravated robbery, kidnapping, aggravated burglary. He kills her after and while he trespasses in her own home, her place of safety, the place where she sleeps, the place where she eats, the place where she comes home to relax. Her own home, ladies and gentlemen. He kills her after and while he kidnaps her. The second he is in that home trespassing and she is not free to leave, that's kidnapping. Doesn't have to be tied up for that to count as kidnapping. The second he comes in and she is not allowed to leave, that's kidnapping. He kills her after he has raped her. And he kills her after getting her PIN number and takes her debit card. Takes those things from her. And I ask you not to get too hung up on the term why. It doesn't indicate that the killing must occur at the same instant as the underlying felony, or that the killing must have been caused by it. Don't get too hung up on the word why. But rather, it indicates the killing must be directly associated with the underlying felony as part of one continuous occurrence. He is in her house. He is trespassing in her house. He keeps her in there with a knife, with wrapping or tying her up. He rapes her, gets her PIN number, takes her card, and then goes. That is all one continuous occurrence. This is a series of crimes during one period. That is what you focus on. These specifications, these are these 4 additional factual questions for you on each count of the aggravated murder. Purposely caused Rachel's death while committing or attempting to commit, or fleeing immediately after committing or attempting to commit, again, those 4 things. Aggravated burglary, kidnapping, rape, aggravated robbery. Aggravated burglary is count 2 of the indictment that you will hear about. Again, same date range. By force, stealth, or deception, any of those. Trespass in an occupied structure, Rachel's home, 3044 Allegheny Avenue, Apartment B, with the purpose to commit any criminal offense. And inflicted, attempted to inflict, or threatened to inflict physical harm upon Rachel, and or had a deadly weapon on or about this person, in this case, a knife, or under his control. Again, force, stealth, or deception, any of these count. And the criminal offense inside her apartment. Serious physical harm and deadly weapon both apply in this case. Again, ladies and gentlemen, her own home. We know she had to leave her door unlocked. You heard testimony about that. The deadbolts, the only way she could lock the door. John Anderson took her key. Her door was unlocked when she left that night. Count 4. Again, same date range. Kidnapping by force or threat. Removed Rachel from the place where she was found and or restrained her of her liberty. For any one of these purposes, we believe they all apply, but any one of these would suffice. Terrorizing or inflicting serious physical harm upon her. Terrorize, think we have that, almost an hour and a half in her apartment. To engage in sexual activity against her will, where's his DNA? To facilitate the commission of a felony, and again, aggravated burglary and or aggravated robbery or flight thereafter. It's not like the TV and movies. Ms. Rauch talked a little bit about it in voir dire. You don't need a ransom note. Don't need to take her across state lines to count as kidnapping. Under Ohio law, kidnapping does not need to be for any specific distance or duration of time or in any specific manner. Again, from the time he confronts her in her own home until he kills her, she is being kidnapped. She is not free to leave. And again, even if she isn't tied up at that point, she is not free to leave her own home. Let's talk about force. You saw the blunt force trauma to the top of her head? The intricate knots to hogtie her? And the blood trail in her bedroom. I ask you to look at that picture. To look. You see the line that will go from the middle of her bedroom to her closet. Dragged. Rape is count 6. Again, same date range. Engaged in sexual conduct with Rachel. In this case, vaginal penetration. Purposely compelled her to submit by force or threat of force. And again, a big thing too is we don't have to prove that she resisted. That is not part of something that the state of Ohio has to prove. But even if so, there is evidence of a struggle. You heard John Kennedy talk about that picture. That was something that meant something to him. Marilyn Monroe was on the ground. Look at her room. That's not how she normally kept it. Male DNA under her fingernails. Hog-tied. T-shirt over her head with a cord wrapped around it. And she's naked from the waist down, ladies and gentlemen. Use your common sense and reason. His YSTR DNA is inside her body, inside her vagina. How did it get there, ladies and gentlemen? Aggravated robbery. Count 8. Same date range. In committing a theft offense upon Rachel, one of the following. He had a deadly weapon, a knife in this case, on his person or under his control. And again, you'll have some and/ors here. Any of them apply. And displayed, and/or brandished, and/or indicated he had it, and/or used the weapon. Recklessly inflicted serious physical harm on Rachel. He has to get her PIN number while she's still alive, guys. It's her brother's birthday. You think Anthony Pardon's going to know her brother's birthday? No. He had to get it from her while she was still alive. While he's committing the theft offense, he has the knife and/or recklessly inflicts serious physical harm. There's a stab wound to the back of her head and neck, and there's a knife found with her blood and hair on it. And this still applies when you steal somebody after you've killed them. Again, this is where we don't want you to get too caught up in the wild. This still counts if you steal from them after you have murdered them. All the debit card transactions. Those are important to look at. He may not be the one always doing the dirty work. He's not the one putting it in the ATM, sliding it to buy clothes. But he's always there. And it also doesn't matter when you see that he gets declined sometimes. That does not matter. Doesn't matter that he doesn't get money each and every time he goes to the ATM. Let's talk a little about before. You heard testimony that Anthony Pardon's girlfriend, Bernita Anderson, lived in Cardinal Creek apartment complex. So yeah, he's been around there. Her daughter, Allison Gamble, lived right next to Rachel, right next door. But Allison moved out in December before the murder. But Bernita still lived there. And Anthony stayed with her when he wasn't staying with Deborah Pardon, his sister. So yeah, it makes sense when Jennifer Lester testified. With the cell towers, his phone should be there. He's staying with her sometimes. That makes sense. And Detective Hughes stated, you can see Rachel's apartment from Bernita's apartment. You can see through to her back door. And I know it's a little bit hard to see, but Detective Hughes testified that that right there is where Bernita's apartment is. You can see through to Rachel's apartment. Right there. So let's walk through the weekend. January 26th, the Friday. Birthday celebration begins. John comes down to stay with Rachel. There's text message. There's testimony to support that. Rachel takes her house key off, her lanyard, gives it to John. Here, I gotta go to work tomorrow. Have the key. Go hang out in Columbus. Drive around. Your testimony that Tina Kennedy, John Kennedy, and John Anderson hang out at Rachel's apartment that night. And that makes sense. Whose DNA is on the cigar? Whose DNA is on the blunts? On the smoking pipe? They sat around and smoked some weed, watched some TV, hung out. The Kennedys leave, and John Anderson stays at his sister's apartment. And you heard John testify there was nothing weird between Rachel and John Kennedy. They had that issue, but everything seemed fine. It was normal. They're having a birthday party. Saturday, January 27th, the day of the birthday party. Rachel goes to work. John Anderson hangs out at her apartment until she comes home. Got an explanation for his DNA. It was embarrassing for him, but he told you guys. They go to the Kennedys' home for their birthday party. They drink some alcohol, smoke some weed, loud music. I think John described it as a great party. Made her a cake celebrating her being single and making money. And this is supported by Rachel's phone records. She's over on the west side, Kennedy's house, near her cell towers. Then she's kind of in the short north area, downtown, because they went to a club. And then they all come back and spend the night at the Kennedy's house. I think John testified that he was way too drunk and he passed out. So he didn't go down to the club. Wake up the next morning and go back to Rachel's apartment. January 28, 2018 is Rachel's birthday. She turned 24 years old that day. John and Rachel head back to her apartment. He packs up, heads home to his girlfriend's, Warren, Ohio. He thought it was, early afternoon, something like that. And then she realizes, a little bit before 2, John has her key. And that's supported by the phone call that you will see that she made to John Anderson at 1:58 p.m. She texts John Kennedy about the key and texts him when she's going to leave. This is when timing becomes important. John testified that they were taking a friend back to Athens, so she couldn't come over right away to get it. So she waited, and then there's a text at 6:17 p.m. that she's leaving in 20 minutes to come pick up her key. And that's on State's Exhibit T2. John testified she arrived at the house, didn't stay long. She's pretty tired from partying, kind of hungover. And she wanted to go home. So took the key and went back home. Testified that it about 25 to 30 minutes to get between their houses. He lived on the west side. Also on January 28th, we know that she's back at her end of town sometime after 7:32 p.m. There's an Arby's receipt. There's Arby's food in her house. Cake is set up on the counter. And I ask you to notice some details. The ketchup is open. She opened up the ketchup, started eating her french fries. But she never got to finish that meal, because you saw it in the pictures on the floor. First missed call, Haley Kennedy at 8:49 p.m. And Rachael Anderson is never heard from again. Ladies and gentlemen, what else was happening around 8 p.m.? Anthony Pardon's phone starts moving towards Rachel's apartment. This is from Detective Howell's geolocation report. And this makes sense. That's Bernita's apartment. That's where the first kid is. Okay, that makes sense. But wait a minute. There are 35 hits over and around Rachel's apartment. So there is a difference between Bernita's and Rachel's. This isn't a confusion of technology. This isn't a Wi-Fi hit reaching too far over. This is Bernita's. This is Rachel's. Where are most of those hits? Rachel's. 35 times, ladies and gentlemen, every minute and a half to 2 minutes, his phone is hitting. I need a Wi-Fi signal. I need a cell tower signal. I need GPS. You heard Detective Powell. Pretty impressive resume. And it's in his expert opinion that this is accurate. And I ask you to think about your own experiences. You trust Google Maps to get you places, right? When you check in places, restaurants, your phone tells you where you are. And it's usually really accurate, and it's right. Detective Howell testified Harding could be anywhere within that display radius. You know where those display radiuses all encompass? Rachel's apartment. Ladies and gentlemen, what is he doing in her apartment for almost an hour and a half? Debit card usage. Anthony Slew. Does that look like a criminal mastermind to you? 61 years old, homeless guy. His details were very consistent with the surveillance we had. He knew the PIN number for Rachel's debit card. 0602, John Anderson's birthday. Why does Anthony Sleep know that? Oh, because the guy that asked him to use it, he told him. That's how he knew the debit card. And if you remember in his interview, he says, I messed it up a couple of times. That's why, I was taking longer, the ATM. 0602, he remembered that. What was his description? A man, he said, a little bit lighter skin than me, younger, chubby cheeks, close haircut, slight southern accent, and a gold chain. You see this gold chain also in the Reich Center surveillance still. You heard Detective Hughes state that he found out Anthony Pardon was in Georgia for a little while. And this is the other interesting thing. Anthony Sleet's DNA is not found anywhere. No swabs, on nothing. But you know he's in the car. You see him get out in surveillance. But his DNA wasn't there. Geolocation. Anthony Pardon's phone is everywhere Rachel's debit card is used that night. Everywhere. Every single stop. You see surveillance of Rachel's car. Anthony Pardon's phone is there too. And if you remember in one of the surveillance videos, you see a hand come out and wipe off the door handle and then come back in. And you'll have these in the back, but I ask you to look at these maps that Jennifer Lester put together, that Detective Howell put together. All these places. Now the times might be off by a minute or two, but Anthony Pardon's phone is there. It's there. It's there. His phone is everywhere her debit card is used. He's just having somebody else do his dirty work at that point. January 29th, 2018. The first look at the apartment. Rachel doesn't show up for work. She's a creature of habit. You heard multiple people testify. She's not answering her phone. That's odd. Trent Snyder was her coworker. He's the one who saw the candle burning. Tried to get the leasing agent to let him in. She said no, so then he called the police. Lisa Richardson was that leasing agent. She goes in the first time, blows out the candle. She said she just briefly looked around. But she did have some interesting details. She had to unlock Rachel's door. It wasn't open. She had to unlock it. There were no signs of forced entry. Because she said she looks for that when you're going to do a well-being check. Officer Sclafani from Columbus Police Department, he couldn't go in with Lisa the first time because they don't have probable cause. And if you think about that, that makes sense. You're hungover from your birthday party before. Do you want a police officer walking into your apartment? The second look on January 29th. Family and friends are now extremely worried. Now, mid-afternoon, nobody's heard from Rachel. But her car's parked in the complex, but not where it should be. It's around the corner. Jonathan Kennedy arrives. He goes in with Lisa. He notices that cake because he helped make it for her. Goes upstairs, and he said he checked the towel to see if maybe she'd gotten ready for work. Did she take a shower that morning? No, it was dry. Then he goes to Rachel's bedroom. And I ask you to think about his description of trying to open that closet door. It was like somebody was pulling back. Finally opens it. Every way I pulled, I was choking her. Every way he pulled. He screams and runs downstairs. I heard Officer Sclafani talk about how he appeared when Jonathan's running down the stairs. Terrified, pale. So Sclafani calls for medics and other officers. Also on January 29th, Agent Dirks, again, quite a resume. Done a lot of scenes, seen a lot of things. The amount of times I wish I would have counted that he said intricate knots. This is a man that has been out to hundreds of scenes, and that's how he described them, as intricate. He couldn't untie most of them. He had to cut it. They were tight. I ask you to look at the coroner's photos. Look at one of her wrists, where the rope is. You can see the indentation of the design. That's how tight those were on her. The heating blanket cord was around the knob. He said that it was wrapped around so many rotations when they had to take it off. And once around her neck. Pay attention to the damage of the door. Pay attention to the length of the heating cord. We talked about saturation stains, transfer stains. Think about what that means, where Rachel was laying at certain times during that night. Also important, Durst didn't find her any debit or credit cards, or her keys in her apartment. And I apologize that you have to look at this again, but I ask you to look at it, ladies and gentlemen, because look at these knots. Look at how intricate these are. And what are these two things tied together? The hairdryer and the curling iron. Those are touching. They're intertwined. Look at how intricate this is. How it's knotted, it's looped through, it's wrapped around and around and around and around. Her hands, look at this. The blind cords were cut. This belt, all intertwined. Intricate knots. Anthony Pardon on January 29th. Where is he? Well, we can tell. We have him at the Rife Center around 10 a.m. Geolocation and surveillance. The Fine Fare Food Mart. Geolocation and surveillance. ExxonMobil. Geolocation puts him there. City Trends. Surveillance. Geolocation. And Deborah Pardon. All put him there. DSW. Surveillance. Geolocation. And Deborah Pardon. Rachel's debit card is being used at all of these places at the same time or very close in time. Again, on January 29th, we talk about Deborah Pardon. You heard from her. It's not easy to get up and testify against family, and none of us envy her for that. She talked about, Anthony asked, hey, you want to go use a debit card? Sure, I'll go use it. She talked about her criminal history. You don't think he thought about that when he was trying to figure out who can I get to help me use this debit card? She uses the card at City Trends and DSW, but who is always around her? Anthony Pardon. Who comes at City Trends and puts an extra pair of shoes on that clothing? Anthony Pardon. She used it by herself, and she admitted that to you. I took it. I used it myself at the Kroger and at the casino. Ladies and gentlemen, geolocation puts Anthony Pardon on the complete other side of town, supporting what Deborah told you, and showing that Detective Hal is not just cherry picking what he's showing to you, what he analyzed in the data. She testified that Anthony Pardon gave her the PIN number on a piece of paper. And she started to get emotional and said later on, she sat straight up in bed because she heard on the news that name. How'd she recognize that name? It was on that debit card. And she said that she talked to Anthony. What did he say to her when she asked him about the card? Don't worry about it. And you can look at the searches on her phone. Deborah was panicking. Look at those searches. And then January 30th to February 1st of 2018. Again, Anthony Pardon. Rachel's card is continuing to be used. And again, where is Anthony Pardon? Are you seeing a pattern? He's at the same locations where her cards are being used. Again, geolocation and surveillance put him in both of these places. The Find Fair Food Mart on January 30th and the Pick and Go on February 1st. And at the Pick and Go, you saw surveillance videos as he's walking down the sidewalk. He picks his scarf up and puts it across his face. Now, if you're cold in the middle of January, or end of January, beginning of February, don't you have the scarf up before you walk into the store? No, he puts it up as he's walking into the store. Why is he doing that? Now let's talk about the after. Agent Durst collected the knife from Rachel's mother, matches the set in her apartment, was still covered in blood, long blonde hair. And she said that she found it in a box of Halloween decorations that was in that closet, that coat closet downstairs. Anthony Pardon was arrested and his car was searched. This is important, ladies and gentlemen. February 8th. This is after the lab advised Detective Hughes of the suspect that they had found. After. The phone was found in the car he was driving. Where do you put your phone when you're driving? Right here next to you? That's where that phone was found. And the hat he wore in multiple surveillance videos. Where's that? Backseat. Residence of Deborah and Anthony Pardon was searched. The hat she wore to City Trends and DSW in the casino. That's found. And Detective Hughes requests follow-up and phone records, more DNA testing, and surveillance were available. He didn't just stop once they found a suspect. He kept working. Let's talk about DNA. I know it was a long testimony. We warned you it might be boring, but it's important. Lindsay Simon came in and talked to you. She's a DNA analyst. Let's talk about mixtures, because I feel like that's going to be something that's going to be thrown at you quite a bit. Don't be misled. A mixture could be one allele. Remember, talk about how sensitive these machines are now. They can pick up one extra allele. And most of the unidentified mixtures could never be identified, even if she had a known standard. There's just too little. It's just not a good quality. And again, we talked about low quantity and quality. Why could that happen? Wiping off would affect it. Time, environment, and some people just shed more. Lottery example. Would you play on Monday if you were 20.5 billion times more likely to win? It's a pretty good example. Again, high numbers for the STR DNA is a good result for a scientist. They even assumed Rachael in some of the statistics to make them lower. Ladies and gentlemen, 20.5 billion was a lower number. 14 billion was a lower number. And then the YSTR. That low number 0 is a good result for a scientist. Anthony Pardon and his male relatives is that group, not some random group of people. We know the group. Now let's talk about where DNA was found. Inner thigh, pelvic swab, and the right wrist swab. YSTR, Anthony Pardon is included in the major profile. And remember, they never say match. This isn't TD. They say included or excluded. Think about the force, the friction that's needed to leave a sufficient amount of DNA and a sufficient quality of DNA on these things. Her body. The hairdryer and the cord, and the curling iron and the cord. STR, Anthony Pardon is included as a contributor. Think about this. The force, the friction, the time spent. Do you think tying those knots was something quick? You think it was something that took a long time to get that tight, to put them together, to think of different ways to intertwine them? That took time, that took force. And also think, she talked about sweat, bodily fluid. That could leave more. Would you be sweating if you're working that hard to tie that knot? The vaginal swab. YSTR, Anthony Pardon's single source profile. No mixtures. Single source. Ms. Rausch and Ms. Simon were talking about female noise. And again, ladies and gentlemen, think about the amount of quantity and quality DNA that had to be there for there to be a sufficient amount for a profile in her vaginal swab. As Mr. O'Brien talked about an opening, Anthony Pardon's DNA is in all the wrong places. It's on the things that bound her, and it's found inside her body, inside her vaginal swab. Dr. Daniels, forensic pathologist, has been doing this since the mid-'80s. His cause of death, strangulation. And let's talk about strangulation a little bit. Petechiae, compress, release, compress, release. Blood flow stops, blood flow stops. And I don't know if any of you noticed this, but when he's testifying about how that could happen, pulling up, like the cords, compress, release, compress, release. Hemorrhaging in her neck, her eyes, hemorrhaging. And he testified that these are all consistent with signs of struggle. The other significant injury, the stab wound to the back of the head. Talk about the J shape, which means that it was turned or was slightly taken out and then reinserted. That's what that J shape meant. Skull fracture. There's a piece broken. What force does it require, ladies and gentlemen, to snap off a piece of somebody's skull? And then the blunt force trauma to the top of the head. Now he stated that the blunt force trauma and the stab wound to the back of the head, he didn't think those were the cause of death. Would they render her unconscious? Probably. Would they have eventually caused her death? That stab wound to the back of the head eventually would have. And the bruising is important to think about. Her mouth. What is over her mouth with such force that is causing bruising on her lower lip? Bruising is a big thing because that means that Rachael Anderson's heart was still beating when this was happening. When she's having her mouth covered, when she's having the cords tied around her. Her heart is still beating. Wrong places, ladies and gentlemen. Where's Anthony Pardon's phone during the murder, kidnapping, rape, and robbery of Rachael Anderson? In her apartment. Where's Anthony Pardon's phone, Anthony Pardon, when Rachel's debit card is being used? He's there. Every single one, except for the ones that Deborah said she did herself. Where's Anthony Pardon's DNA in Rachel's home? Not on any blunts, not on anything that was used to drink. It's on the things that caused her murder, the things that caused her kidnapping. Inside of her body. And on her body. On her pelvic swabs, on her inner thighs. That's where his DNA is. And we have to talk about evidence presented to you in this courtroom, in this trial. Ladies and gentlemen, is there any reasonable explanation that you have heard as evidence in this trial for that man's DNA to be in those places, for that man's phone to be in those places? Reason and common sense. You all said that you would use it. Trial does not mean this is a complicated case. Yes, there is a lot of evidence. But if you put it all together, it's not that complicated. The defendant went into Rachel's home. He kidnapped her. He raped her. He stole from her. He robbed her. Use your reason and common sense, I beg of you, and to look at the evidence that's presented in this courtroom. We would submit to you that we have proved beyond a reasonable doubt that Anthony Pardon committed all of the crimes that he has been charged with. We would ask you to find him guilty of all of those. Thank you.
Thank you, Ms. Van Coolen. On behalf of the defendant.
How we know? Question here is who? Mr. O'Brien, Ms. Rouse, and Coolin, Your Honor, distinguished co-counsel Isabella, Anthony, Amy, Carla. Ladies and gentlemen, I'm gonna need the electrum because I don't have the strength I used to have, so if you bear with me a minute. Good morning. We started this process on February 3rd. Now we know you came down on January 24th and we went through some stuff, but this process, this particular trial, we started on February the 3rd. And we started with a process called voir dire. And Ms. Dixon asked you some questions. Ms. Rouse asked you some questions. I want to express my gratitude on behalf of my co-counsel, Anthony, and the parties for your willingness to serve also. I agree with Ms. Van Coolen that as attorneys or parties in terms of trying to deal with this, oftentimes, we human beings, we may hear evidence that's different from the way you folks remember it. And again, I will mirror Ms. Van Coolen. If I say something during the course of my presentation, disregard what I say and rely on your collective memories. I won't do that on purpose, but I can make a mistake. So that can't happen. if during the course of these proceedings, I don't know if I had a chance to tell you folks, but if I do something, or I said something, or my co-counsel said something that offended you, mainly it's probably me, but hold that against Larry Thomas and not view the evidence against Anthony Parton. Hold that against me. And I think you will. If he got that kind of hold it against me. I think that we know, I think you were asked about this, and this was going to be a tough process. We had kind of anticipated what you were about to hear and see. And we asked you about that extensively because we know that as a human being, if you got any kind of heart at all, and you see what you saw, and you heard what you heard, it would be impossible not to have feelings, not to have emotions. And I think that's what we have to, and that's what we rely on you folks when you say it. You can set those feelings aside. You won't get an instruction from the judge that tells you there's a problem when you let sympathy and bias enter into your thinking process. Because then it affects the way you look at the evidence. If you're feeling a certain way, you tend to look at the evidence to support the way you feel. So we ask you not to do that. And each and every one of you took an oath and said you would do your best not to let that happen. Uh-oh. If I fall, y'all. Anyway, I move a lot. Y'all know that. But the point being, a lot of the arguments you hear is actually asking for your sympathy. We know how this thing happened. That's not an issue. And yes, it was terrible. In our own house, this and that, soliciting sympathy. You have to put that aside and look at the facts as they were presented. Not the sympathy. That's the hardest part. That is the hardest part. But you said you could do it. Well, look, she was this and this and this and this. Of course, we know that. But what we don't know and what we can't put together is who. Who did this? You've heard from the experts. You've heard from, I think, 14 witnesses. 13 live witnesses in an interview with Anthony Slew. And I would disagree with the state because I don't think not one witness came in here and said Anthony Parton was in that apartment. Not one. Detective Howe told you that he gave you that map, showing you where the phone hits. Could be anywhere. Could be. Ladies and gentlemen, those are key words. Could, may, might have. When you ask yourself that in the back, that means the state has not proven to you beyond a reasonable doubt that it is. If they say Anthony could have been there, what does that tell you? Reasonable doubt. Because they didn't prove he was. If it could have been his DNA included in a YSTR, what does that tell you? Reasonable doubt. Because they can't say beyond a reasonable doubt it was him. When the Detective Howe gives you that scenario, and he said, well, Mr. McCool says it's not cherry picking. Tell you why it's cherry picking. What is missing from that display? Rachel's car was brought back to the apartment. What now? Why don't we have a trail showing you said one going down James Road, seen one going down Main Street. Why didn't we have one showing who brought that car back? The car was bought back. And Anthony Parton's phone was part of that car. And shouldn't you have something showing when that car was bought back and him being in that vicinity another time? Was it there? That's what I mean by cherry picking. Well, those 4,000 or whatever pages, it doesn't show you that. You know why? Because it doesn't show Anthony having that phone in that particular car. The state wants you to jump to a lot of conclusions. They want you to say, well, I'll tell you something else, I'm going to get back to that. Anthony Parton used a credit card. And you heard from every witness that came up, object was to tie Anthony Parton in marriage, credit cards to the homicide. The use of the credit cards to the homicide. Because they couldn't put him in the apartment. Couldn't put his DNA on the murder weapon. Say, I'm going to give you an example. Detective Hurst came in, and I don't know if you heard, or maybe it's just me, could be my imagination. He clearly explained to you that he took swabs. You'll go back there and you'll have an exhibit 65, where he swabbed the curling iron and the dryer, hair dryer. And when he swabbed that, I asked him, he told you folks, I was careful to swab the areas where somebody would touch. I would do that. That was when he did his investigation. Now, for some reason, those swabs we don't hear about no more. And I asked him, I said, well, Agent Durst, it's good to put these things together. Can't you have that transfer of DNA? No problem, I can do that, it's not a problem. And he packaged them together, sent them down to property before Miss Simon got them, and separated them out. You'll see them in the photographs where she separated them out. But then, they had a suspect, and they had a sample of Anthony's DNA. The swabs that were then tested for those two items now have Anthony's DNA. Now, what's unusual about that? Well, okay, mister, you saw the elaborateness of that time. You saw ropes, belts, ignition blinds, cords wrapped around her neck, hang on and do everything. You just heard that when you're doing all this, you're sweating. Sweating the storm. Where is the DNA? Where is the DNA on all the rest of this stuff? Here's a guy who makes sure there ain't no DNA in this whole house. On nothing. No ropes, no clothes. The knives that were up in the room weren't tested, but be that as it may, no DNA. But then you look at the picture, the final items that are used, allegedly, there's DNA. No fingerprints, no anything. But, and then I think the scientist, Miss Simon told me, even on those items, how much DNA? I don't have to recap that for you. You know, we're talking about minute amounts of DNA, period. you're gonna have a lot of evidence back there, and they're gonna want you to kind of skip over, but you wonder, in a lot of these DNA samples, you know, especially like when Miss Simon did the dryer and the curling iron, you're asking, well, Agent Durst was specific about where these was, and that can be important for transfer. But Miss Simon says, well, but I can't tell you where I got the DNA. I don't know if it was on the cord, on the handle, I don't know where it was. You know, you want to know, because how easily DNA is transferable. You just want to know. Ladies and gentlemen, there's a lot of speculation that the state of Ohio wants you to do in this case. As I thought about it last night, you know, the state of Ohio has a duty to prove each and every element of each and every offense. You're going to have to jump to some conclusions because things weren't proven. So they want you to assume that everything that happened to Rachael Anderson, right, happened between the hour and a half, between 7:59 and 9:25. And they want to establish that time by what? And so you get to go back and look at that. And you keep that in mind, knowing that somebody used her car on that night, and somebody bought that car back. You use that in light of what Dr. Daniels told you in terms of the times for the rigor mortis, livor mortis. I lose myself sometimes. Please bear with me. But he told you, he said 24 hours or 3 hours. You can look at the damage. You can see what happened. 24 or 3. State of Ohio wants you to say, well, you know what? DNA, STR DNA, was found inside of Rachael. Nobody came in here and told you that those vaginal swabs were from the inside of her vagina, did they? They want you to assume that they were from the inside of her vagina. They could have been vaginal swabs from the outside of her vagina. You never know. They will say, well, no, how did the YSTR, that ain't even his, it could have been his, get on the inside of her vagina? They ain't bringing in somebody and say, you know what, these swabs came from the inside of her vagina. I want you to assume that. They have a duty to prove it to you. They have a duty to bring somebody in here to testify to that. You can't just assume. Where did it come from, ladies and gentlemen? Ask yourself, you tell me. You're going to have to say, I think, because I'm nobody in here, I think they came from the inside of the vagina. Folks, I want you to bear with me. You know what? As I've gotten older, they keep making print smaller. They keep making it smaller. I want to get on them about that because ain't nothing happened to me. I know it's the print, so it's a little hard for me to read. But bear with me a little bit. I don't want to go back and cover everything. And I know you folks are saying, well, Larry, during the cross-examination, you brought up names of several individuals and the reason you were bringing those names up. And we talked in terms of John Kennedy a lot. And you're going to see that a lot of times you can actually see the turn in an investigation. When it turns from being an actual investigation till it turns into an information gathering process that has to lead towards conviction. And so you have to draw the line, not really that hard, because Detective Martin Hughes told you. Once Anthony Pardon was identified as a suspect, what happened to the investigation in this case? And we're talking about February 8th, ladies and gentlemen. He told you. It became an information gathering process to convict Anthony Pardon. So everything done after February 8th was done in order to convict him. So they stopped doing an investigation. So I said, well, Detective, how do you eliminate any other possible suspect? Because even from Rachel's brother John, he said, listen, when this happened, and he was reluctant to tell it, but he got out, we initially suspected John Kennedy. Why? For several reasons. For several reasons. John had some issues, and he felt a certain way about Rachel. And there were sexual vibrations and etc. There was arguments, he's calling her names. He had an interest in her. And so, we said, well, Detective, we understand he's the suspect up until you identified Anthony Pardon, but what did you do? He said he had an alibi. John had an alibi. Because that's what I'm saying. With the state, they want everything to happen during this particular period of time. Okay? But there was a large period of time that's unaccounted for. A large period. So you said, well, John had an alibi. Yeah. What was his alibi? There was no male DNA on that knife. Did you stop there? Did you stop there? Why do you stop there? Because the suspect in this case is a male. And we don't want nothing that leads us away from him. I asked again, I said, Detective Howell, that good work that the state of Ohio is relying upon for this geo-tracking, you know what I mean? Did anybody check your work? No. No, nobody checked my work. So you ask yourself, ladies and gentlemen, you went in, you wanted a procedure or something done on you, and the doctor told you you had a problem. You asked the doctor for a second opinion, and he said, it's okay, I'll give you one. You got a problem. Is that a second opinion? Is that checking the work? It's the same guy telling you the same thing. When he talks about this work, that's why he wouldn't go as far as to commit as to say when he draw all those circles up there What does that really mean? He couldn't tell you if he was in any apartment. If he ever went in any apartment. He could have. That's good enough. That's good enough. If we can put them near, then we can get jurors to make the connection. That's all we want. Put them close. I can put them close a lot. Anybody check to see if this is accurate? You got problems with iPhones, but you're doing tests with iPhones? He told you. If it's off by a few feet, it's off, throws everything off. He told you he left out plenty of evidence in this case. Now, do you think that evidence was favorable to Anthony Pardon? We sit here. One of the reasons that today, in this modern time, you can't get away from videos. You can't. They're everywhere. And they help you folks in making decisions. And when Anthony slept, when you watch his interview, he keeps telling the detective, the person I got this card from came out of this store. And we talked for a few minutes. And it's on video. Now, you've seen, based on the timeline that the state created, how many minutes you have before the use of that first credit card and that decline versus the video and the time that it was ordered. Yeah, we would like to have it, we don't have it, but it's not Anthony's fault. You could see who was on that video and who was driving that. But guess what? We ordered the video down to the last minute. So things that would be helpful for Anthony Pardon don't exist. You have pictures of Rachel's apartment. Again, you don't have to make a big jump, but the reason they said that there's a robbery, because they want you to think that if this credit card is out here being used, it was taken. There's no evidence of that. And well, what do you think, ladies? You think Rachel gave who, what? We don't know. That's not your job. That's the state's job to show you that. But you look in the apartment and nothing's taken. You know, you got a computer there. You got her phone. You got numerous items on the table. I asked Agent Durst, she go upstairs. Ain't under the dresser drawers pulled out. Nothing disturbed. Somebody said, well, maybe that's not the way she kept it. Nobody came in this courtroom and told you that was not the way she kept her apartment. Her brother was there the day before. What was disturbed? What was in disarray? Where's robbery? Where's the evidence of the robbery? And where's the evidence that he committed a robbery? Burglary, trespass. Again, We want you to take this big leap, because we're going to fill in this puzzle. But we need you to take leaps to fill this. Where is the burglary? We think, and there might be many theories, that the door was unlocked so somebody must have came in. Somebody might have been let in. We don't know, but we want you, folks, to say somebody trespassed. What evidence was put forth in this case to say that? That connection, that working backwards, credit cards working backwards means they had to be taken through some kind of stealth or trespass. Not frontwards. Where's the evidence of the trespass? Fill in the puzzle. Have to assume yes. What logical person would allow somebody to... That's not the point. The point is proof beyond a reasonable doubt. You got to be firmly convinced it happened by the proof that the state gave you. Not by speculation. Not looking at the nature of this and saying, well, you know what, it had that. They have to prove it to you. You might think that. I think that wouldn't happen. I think it is not proof beyond a reasonable doubt. The state has to prove it. I know it did. Because the state proved it to me. The rape. You know what the evidence of rape is? Because the way her body was found with nothing on the bottom. Okay? And so, well, no, the vaginal swab. And nobody come here and told you that was the inside of anything. No penetration whatsoever has been proven in this case. None. But the way she was found, well, why was she found without no clothes on the bottom? That's your proof. There's no direct evidence in this case that Anthony Parton did anything other than use some credit cards. None. They want you to tie his conviction to where that phone went. And they want you to conclude that phone only went where Anthony went. They didn't prove that, but they want you to conclude, well, listen, if that's Anthony's phone, and he's where the credit cards are used and the phone is there, then he did this. Then he did this. And ladies and gentlemen, I don't think that's filling out a puzzle for you. Again, with that DNA that they want to say was his DNA in the compartment, folks, I need you to, again, look at the circumstances. And does it make sense in terms of the totality of all the circumstances here? Somebody would remove every other sign, but in the most obvious places in the world, you know what? I'm going to take all my DNA from everywhere else, But in these particular instances, I'm gonna put it here. You have to use your common sense in terms of that. And Judge McIntosh is going to give you a copy of the jury instructions in this case. And this is the law, and it tells you what has to be done, what law you are to follow to apply to whatever facts that have been proven beyond a reasonable doubt to you. And ladies and gentlemen, I think that once you had an opportunity, and I always say this, I don't like saving it till last, she'll tell you first, but normally, jurors, I think of a few things, but they ain't nothing like what y'all think about collectively. When you get back in that room, there'll be some thoughts about subjects that I didn't even think about. I'll be amazed at sometimes what jurors think about. And I know with this cross section, there's probably going to be a lot of that goodness coming out. And so regardless of what your verdict will be, we will respect it. Me and my co-counsel appreciate the fact that you paid attention, that you gave us your word, you would listen to all the evidence, and we think you have. Now when you go back there, you'll reach whatever logical conclusion you can based on what you've heard. And I'm sure there's some things here that I missed that occurred to people, and I wish you shared that with other members. But anyway, ladies and gentlemen, we do appreciate your time and your undivided attention during the process of this case. So thank you very much, ladies and gentlemen. Thank you, Your Honor.
Thank you, Mr. Thomas. On behalf of the state.
Thank you, Your Honor. May it please the court, Judge McIntosh, Mr. Thomas, Ms. Dixon. Ladies and gentlemen of the jury, as I sat there and listened to Mr. Thomas, I wondered if he was in this same courtroom as me for the last 2 weeks. He said the state's case is based on speculation. And he asked you to set aside any bias or sympathy. The state doesn't want you to decide this case based on those gruesome, horrible, terrible photographs that we had to show you. We want you to base your decision on the cold, hard facts. Apparently, Mr. Thomas is willing to say that Detective Hal's geolocation evidence is okay when it puts him at the Fine Fair Food Mart. That it's okay when it puts him at the BP. It's okay when it puts him at the BP. It's okay as he is going out Main Street and Livingston Avenue within the hour of the murder of Rachel. He wants you to think that when we see his photograph just down the street here at the Rife Tower, and at the same time, guess what? His phone's there, that all those geolocation evidence is sufficient to show he's using the credit card, he's with his sister. But on the night of the murder, well, let's just disregard that geolocation evidence. That doesn't fill in a gap. That doesn't complete the puzzle. I guess, again, as I sat there, I thought, well, about the only thing that would satisfy Mr. Thomas is if Rachael Anderson walked in here and raised her right hand and told us who did that terrible thing to her. Because Judge McIntosh would tell you that our burden is beyond a reasonable doubt, and I think we talked about it with some of you in voir dire, that it's not beyond a shadow of a doubt or beyond all doubt. Judge McIntosh would tell you our burden is reasonable doubt is something based on reason and common sense. It's not mere possible doubt. And everything Mr. Thomas said was raising a mere possible doubt, but it's a doubt that is relating to human affairs or depending on moral evidence. Everything's subject to an imaginary doubt.
And Mr. Thomas gave you a parade of imaginary doubts. First, I think, he said that Detective Hughes stopped the investigation as soon as the defendant's DNA was found. That's not true. You know it's not true. Because what did they do? And he's indirectly, I think, pointing the finger in one way or another at John Kennedy. They went out and got a swab from John Kennedy. They sent John Kennedy's DNA to the crime lab. And the criminalist here yesterday said, John Kennedy's DNA ain't on the curling iron. John Kennedy's DNA ain't on the hair dryer. John Kennedy's DNA, most importantly, isn't on the inner thigh, the vaginal area, or in the vagina itself. John Kennedy didn't kill this woman, as apparently Mr. Thomas seems to suggest. The cold hard facts show his phone at every place within the hour, the next day, and the following day. And most importantly, who tells you, besides the phone, that he was there? His own sister says, yes, that's me at the DSW. Yes, that's Anthony wearing the hat he wears every day, the red and black New York hat. That's Anthony there. We know it's Anthony there. We know he's at DSW. We know he's with Deborah at Northern Light Shopping Center. That geolocation works when Mr. Thomas wants to say he just used a credit card, but apparently it doesn't work in his mind the night of the murder that puts his phone there. And as I recollect Detective Howe testifying, at one point it was within 20 meters. There are 35 hits, as Ms. Van Keulen said, over that hour and a half, from Wi-Fi, from cell towers, from the GPS, 3 separate ways that put that phone in Rachael Anderson's apartment. Then we have the use of the credit card. Those cold hard facts showing that he's where he shouldn't be in the apartment at the time of the murder. He's there with his sister. He's there with Mr. Sleets. One thing he talked about, and I made a note, was what about Rachel's car being driven over there to the R&M Food Mart? And what about it being driven back? Where's the phone information on that? As I recollect that Jennifer Lester, the BCI agent, who also did some phone and location things, testified there was no activity on the defendant's phone during that time frame. And as I recollect, she said the phone's turned off, that you won't have those 3 things working on the phone, the GPS and the Wi-Fi and the cell tower bouncing or pinging, as I think was the technical term. So if the phone was off, then that would account for that. And we don't know. We do know that the car was taken from the home. We do know the keys were missing that had never recovered. Keys on the lanyard were missing, with the car keys, with the house key, and the house was locked the next day. As we go through these different things, Mr. Thomas also said that there was no witness that walked in this courtroom, raised their right hand, and said that Anthony was in the apartment. Well, even though she didn't testify, Rachael Anderson tells us he was there, because his DNA is in her vagina, the vaginal swabs. Dr. Daniels, yesterday afternoon, Ms. Roush, when she talked to him, said, now, were those vaginal swabs taken before or after the autopsy? He said, no, the vaginal swabs were taken before the autopsy. And a vaginal swab, Mr. Thomas seems to suggest, is something other than a vaginal swab. A vaginal swab is a swabbing of the vagina to see if there's foreign evidence, be it saliva, be it blood, be it semen, in the vaginal area. That supports the rape. Judge McIntosh will tell you, and at least in some of the questioning, and then here again this morning, the definition of sexual conduct, which is what is rape by force, is having sexual conduct by force or against the victim's will, that penetration, however slight, by any body part or item constitutes penetration. The defendant could have stuck his finger into the vagina and it would leave those skin cells that we heard about. The defendant could have stuck his penis in there as well and not ejaculated. And if ejaculated, there may not have been sperm in the ejaculation. All those things happen. All we do know is through a finger, through a penis, through an ejaculate, one way or another, that man sitting right there in this courtroom, his DNA is in her vagina. And it's not only just in her vagina, it's on her thigh, on the inner area, and it's on the bindings that bound the woman. Talking about the swabs that Agent Durst took, and then the criminalists from the crime lab also took, I think there was a question when Mr. Durst testified, did you swab the whole length of that cord? Again, presumably to suggest somebody else's DNA may have been on there. And he said, no, I just swabbed around the bindings. Yesterday, the scientist from the CPD crime lab said, I swabbed the whole thing, the length of that. Also, the item itself. And by the way, why would the defendant's DNA be on it at any location? Be it on the handle, be it on any part of that 4, 5, 6 foot cord. His DNA is there. I didn't hear the word plant, but Mr. Thomas came pretty close to saying somehow that his DNA was planted in the vagina. It was planted somehow on these cords. I mean, how else would it get there other than he was there? He touched those cords, those terrible cords that bound Rachael Anderson's legs and wrists. And we heard that DNA can be lifted more easily off certain items than others. The defendant had some gloves in that car. Mr. Thomas talked about, well, there were no fingerprints. There were no fingerprints in the car. We know that Anthony was in the car, and we see him get out and go in and use the car, who testified via the videotape. So we know he was in the car. We saw him get out. His fingerprints aren't there. His DNA's not there. You can be in some places and not find those things. So when Mr. Thomas says that there's no fingerprints, well, we have gloves and we also have fingerprints aren't always left, as the experts said. If there's any speculation in this evidence, ladies and gentlemen, it's by Mr. Thomas in suggesting that the state hasn't presented a strong, powerful case. There was investigation after February 6th and February 8th. The other DNA was collected. Tons, I might add, of phone records were collected. The phone records would speak for themselves, be they Miss Rachael Anderson's, whether they're John Kennedy's. I think Deborah Pardon, her DNA was obtained. Since she was using the credit card, was she there in the apartment? No DNA of Deborah Pardon there. No fingerprints of Deborah Pardon there. Her DNA was sought, examined, and the experts tell us it wasn't there. So when Mr. Thomas wants to suggest everything stopped on February 6th and Detective Hughes wanted to just build a case on the defendant, that's not at all true. records were sought up until sometime the middle part of 2019, we heard. Detective Hughes worked on the case after Detective Welsh got off of it. His alibi. I don't know how else you check an alibi other than saying, who were you with, and talking to that person, and they confirm it. John Kennedy's phone wasn't down there. John Kennedy's DNA wasn't down there. So any suggestion that he somehow is complicit is just speculation, and I might add, quote, imaginary doubt that Mr. Thomas is planting with you based on this evidence. Remember, Detective Hughes said, and I'm trying to go through a checklist here, the state has a burden of proof, so we have an opportunity to what they call rebuttal, and that is I'm trying to hit the points that Mr. Thomas raised that in my view were quote-unquote imaginary doubt, and one of those was he said there was no video of the man that went in the store that gave Mr. Sleets the credit card, which surprisingly, as I recollect, Detective Hughes said, we didn't identify someone until several days later. We went and we got certain information from the people at the first location, but when we went back, they erased it. They're on an auto erase every certain amount of time so that they don't have to keep using and buying new recording items. And so Detective Hughes again tried to find that. He tried to find Mr. Sleet. I think he said he put a hold on him, and sometimes he puts a hold on somebody and they're out for a year and a half before they find somebody. He went back to the same location, he said, to try and find Mr. Sleets, and he was unable to do so, then found out Mr. Sleets was dead, and at least he was able to testify from the grave through his video statement. Rachael Anderson wasn't, was she? When he talked about the robbery, no evidence of robbery, no evidence of the burglary, well, the way she was bound and gagged, raped, hogtied, and murdered, he would want you to think that she invited the person that did that into the house and that they didn't trespass by forced stealth or deception. We know it's not forcible entry. But he certainly was in that apartment within 20 meters from 759 to 925, and about 946 or 49, that credit card was used not far from that location. And then over the next several days, it was used. The evidence of rape is shown, the state submits, by the DNA evidence, for which there's no other explanation. The robbery is shown by a theft offense, removing the credit card from the premises and using it. That's a theft of the amounts, whether it's $100, $200, whether it's purchasing shoes at City Trend, whether it's buying shoes up at Easton. Those are all theft offenses that were part and parcel of the crime that happened on the 28th. The state submits, ladies and gentlemen, that what Mr. Thomas has done is plant at different stages so-called imaginary doubts. Because this case, on that date, January 28th, on her 24th birthday, Rachael Anderson in her apartment with her Arby's food bought at 7:30, lighting a candle, putting her birthday cake on the counter in the kitchen. Someone took her from downstairs, upstairs, that's kidnapping. Someone bound her, gagged her, hogtied her, that's a restraint for purposes of committing other crimes, be it rape, robbery, or part of the burglary. Someone's DNA was in her vaginal area, and that someone sits right here. And that someone is Anthony Pardon, and ladies and gentlemen, that someone is guilty of each and every count and guilty of each and every specification. And I want to thank you for your attention throughout the trial.
Thank you, Mr. O'Brien. All right, ladies and gentlemen, okay, we're going to go ahead and break for lunch. And this would also be a good time if you want to move your vehicles to do so as well. If we can get you back here, let's say at 1:15. Okay, at 1:15, I will provide you the instructions of law. Okay, again, the admonitions still apply. Okay, yes, you've heard all the evidence that you're going to hear. Yes, you've heard the arguments of counsel. Okay, but you've not heard the instructions of law that you're to apply to the facts as you find them. So the admonitions still apply, and it's important that you not have a conversation among yourselves or with anyone else. So we'll get you back in the jury room, let's say at about 1:15. At that time, I will provide you the instructions of law. All rise for the jury. All right, so you're going back right around 1:15. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Well, that's all good. I could not even believe when she said that, because I was like, oh,